Okay. All right. I see the light. We're on. Good morning. This is the Court of Appeals oral argument document for Thursday, January 13th. This is the second case of our docket today. Let me introduce my colleagues. I'm pleased to be sitting with Judge Steve Hill of our court and Catherine Gardner, also of our court. My name is Gordon Atchison. I'm the presiding judge. I am also a member of the Kansas Court of Appeals. So we've got no senior judges, no visiting judges. You just got three of the tired old Court of Appeals folks today. This case is DA versus CAJB, DP, and SP. Sounds like a alphabet soup, but I will remind counsel that we have read the briefs. We are generally familiar with the underlying facts. This has been set for our standard 15 minutes per side. If the appellant wishes to reserve a portion of that 15 minutes for rebuttal, please let me know at the start of the argument. With that, I will turn it over to Mr. Booth as counsel for the appellant. So you may proceed, sir.
Yes, may it please the court, Joseph Booth appears for DA David Allegaria as the petitioner appellant, and I would like to reserve 5 minutes for rebuttal.
You have it. Please proceed.
This case is an interesting expression of a series of cases that have been coming before the court ongoing that deal with parentage actions, and the interplay of adoption. What bothers me most about the way this case has come forward at this point is, I think, best expressed in a hypothetical. Imagine if husband and wife have not been together for quite some time. Wife and boyfriend have a child. Then wife is not interested in taking care of the child. So boyfriend winds up raising the child on into kindergarten. He's the biological father of the child, but the birth certificate shows husband and wife as the legal parents of the child. At some point, for whatever reason, husband and wife decide to consent to an adoption. Does the child and the father, the biological father, have any chance to stop that adoption? And if you go through the way in which this case came down, that answer would be no, and that answer can't be right. That our interest in preserving the health of the child, as the Amicus Brief both express, and our interest in preserving the rights of the putative father all interplay. As the court
counsel, may I interrupt you, because we don't have much time, and I've got some questions that I need answered about the record. You'll know the answers, and Mr. Hazlitt, I'll ask you the same questions when it's your time to speak. But tell me this: did the adoption court terminate parental rights and issue a final adoption decree?
Yes.
All right. And did the adoption court ever rule on grandfather's motion to reconsider / notice of appeal? Did the adoption court ever rule on that?
No.
Is there a pending appeal by grandfather in that particular case?
Yes, in the sense that once that adoption decision is finalized, then it would be ripe for appeal on the question of whether or not he has standing.
So is that appeal pending now in our court?
Oh, no, I'm sorry.
Okay.
I may have phrased that poorly.
All right.
What I mean is it is ripe for appeal, I guess would be the way to say it.
All right, because my question is concerning res judicata, issue preclusion, things of that nature, and I need to know the finality of that judgment. And we've got a record here that's not too clear about what's going on in the adoption case. And the last thing, this is a factual thing. Did grandfather argue to the adoption court that he was the presumptive parent of EA? Or did he ever get a chance to make that argument?
Well, he appeared in court. I was trial counsel in that event. He appeared in court with notice that he had filed this parentage action and requested to make a record. And the presiding judge did not allow him to make a record, said that they would review, and then ruled that he had no standing.
Was there ever any attempt to consolidate? You're in the same court, to consolidate the adoption case with the parentage case?
Not that I recall by any party.
Or by the judges. I mean,
Right.
Yeah, we'll talk about THHM later, but you see where I'm headed on that. So
Absolutely.
proceed with your question.
Well, actually, before you do that, I have a question. Was there some sort of legal bar to DA seeking to formally adopt EJA? Could he have done that?
Yes, he could have done that. I'm aware of no legal bar. You'll note in the record that his son executed a consent. The birth mother did not.
And I'm speaking even sort of, I don't know if it's hypothetical, but even earlier than that. I mean, the record seems undisputed that DA had physical custody with a written document from the biological father, his son, and had physical custody of the child for a number of years. During that time, are you aware of any legal bar that would have precluded DA from adopting EJA, assuming again that the consents could be acquired or that the adoption went forward without the consent, with a termination of parental rights? I mean, he could have done that.
Yes.
Basically. Okay.
Yeah. As happens in a lot of these grandparent type cases, when you're dealing with a variety of family members, there is this hesitancy to reach out and begin to spark litigation and create turmoil within the family. I don't know what kind of turmoil that may have created here, because for all intents and purposes, it appears that as this child grew up over these years, this was a pretty harmonious relationship until the adoption came by sort of out of the blue as far as my client was concerned.
Well, I guess I appreciate that, but the question, I mean, that decision to avoid family turmoil has legal consequences to it. And it seems to me that this litigation in the adoption case on behalf of the paternal grandmother and her husband is one of the consequences of that choice.
Yes. History that one in this situation.
Okay. I kind of wonder where, in some sense, in the broader scheme of things, where that leaves us, because there was a legal avenue open to DA to get where he wanted to be, and he didn't take it. Really? Yeah. Does that figure into this in some way, or is that just me not understanding this area of law and pondering something that isn't of significance here?
Well, as things moved along with the acquiescence of mom and the active agreement of dad, yes, it would have been far happier and wiser and safer for the child had David, grandpa, gone ahead and adopted the child as soon as that consent was signed, or taken that step forward at any time. I can't tell you, and the record doesn't show the reasoning from the heart as to why that didn't happen over time, other than the fact that everybody began to rely on this, and it became the way in which the family operated, to the point of even getting the passports as one of the facts, where the child had a passport with David listed as father.
I've got another question for you that, and it's more technical. His son gave the father consent to adopt his son, correct?
Yes, that was the second two documents.
But that's time sensitive, isn't it?
Absolutely.
They're only good for what, about a year?
I don't recall off the cuff, but yes, right. They do expire.
So, but this boy lived with the grandfather as his son for 6 years.
Yes.
Okay. And so to get to the facts, if I understand them, then grandmother comes along, has a visit, and goes to court and files an adoption proceeding.
Correct.
The same day, next day, a couple of days later?
If I remember the chronology of the facts correctly, what happened was the child was picked up for visit with grandma. And the next thing that happens is that Grandpa David is served with the temporary orders granting temporary custody of the child for the adoption proceeding, and the child just simply did not come back. As he phrased it, maybe apocryphal when it comes to the facts, but the child's bicycle sat out in the driveway after that, just waiting to be used. And
he's not allowed. Grandfather is not allowed to enter an appearance into the adoption case because there's a court order years earlier that his son is the father. And so he has no standing to appear, even though he's raised this child as his own son for 6 years. He's not a real party in interest because the statute doesn't allow for that. Am I saying this right? Am I getting the facts halfway right?
Well, the combination of facts and law is what the trial court ruled. There is an interesting issue in the sense that there's a party in interest and interested party within the probate code, and they're both there. The adoption code has the party in interest, and it's a narrow set of people, but the overarching, differently phrased, interested party in the probate code for things like going for appeal is not eclipsed. So I believe the court could have ruled and should have ruled that, one, it should have pursued and basically cleared the title on the kid on this competing interest on who the father is. The court should have looked to the best interest of the child as far as a concern over what this disruption in the child's attachment bonds would be, and should have brought in this case and resolved this question either by a parentage action in and of itself on its own footing, or by still taking that priority that the statute speaks of. But that's the statute that we go to look to see how to resolve questions of parentage before we terminate rights and go forward with an adoption. Now,
you're familiar with that very interesting opinion in NRA THHM, are you not? I'm going to ask you, Mr. Booth, and then I'm going to ask Mr. Hazlitt when it's his term. What does that case stand for? We've got a plurality opinion. We've got two dissents. We've got a dissent that concurs in the result. So tell me what, in your view, what does that case stand for?
I'd say two things. First of all, it stands for, when you look at the plurality opinion, it stands for the turmoil that is resident within this new idea that parentage can be created by contract, whether or not that contract is written or not, by a course of conduct, and that we're going to protect the child's best interests by recognizing their constitutional right towards parentage in what they're doing. The plurality grew, it's really three opinions. Justice Segal believed that we broke the Parentage Act. The dissenting opinions.
But he agreed with the result.
he sided with the result of the majority because he disagreed with the way the structure of what we've created here in the Kansas Parentage Act by having this body of cases that say that we can create a parent-child relationship that's not biological and it's not adoption, but arises out of the agreement between the parties and the parent and for the benefit of the child. And so he disagreed with that. So he aligned with the majority. Now, the majority doesn't disagree with any of these premises. They disagreed, and the case wound up being rejected on procedural grounds. And they specifically state that we're not ruling on the merits, but on the procedural grounds.
Do you get the impression in your reading of THHM that a determination that a grandparent has no standing is not an appealable issue? They didn't decide that. They didn't come out to decide that, but they certainly cast doubt on it, did they not?
They did.
And if you can't appeal that, what recourse do you have?
I believe what David did, and that is that he wound up with the parentage action where he could be a party. And then that inures to the ability to come into the statute. The trial court was basically focused right away on 592136 and talking about how that termination of rights process takes priority over other cases. But that isn't, in my opinion, what the structure of the law is. Yes, the adoption would take priority, but it doesn't circumvent and eliminate any divorce, parentage action, et cetera. In fact, it spills straight towards that parentage action. So whether or not you have standing may be generated from the roots of that parentage action. Get that resolved, and that would be a standing question in the next step, which would be the adoption case. But the adoption case went forward as though there was a rush to it when there was no reason to just do that. There was no reason to ignore that plea.
And then there was another dissent that referred to judicial dysfunction.
I recall that.
And where you had cases in the same court, and it's a very real problem, because you could have similar issues on similar cases and have one judge rule one way and one judge rule another way, and you've got competing orders. Who's going to prevail?
That's absolutely the case in the base case here. We have a parentage action on file, and the adoption goes forward without being even able to argue, put forth a proffer in the adoption itself. So how can my client be barred by any of the litigation that happened in the adoption when he wasn't allowed to be any kind?
The THHM also says you have to have legal standing as well as common law standing.
Yes.
And let's assume you have common law standing for the moment. Do you have legal standing? In this case, in the case you're arguing today?
Yes.
And what is the basis of that?
The basis of that would be presumptive parenthood, and the body of law that says that you can establish a parent-child relationship by having agreements and course of conduct, openly, notoriously holding yourself out as parent, which David did for 6 years. And that was never questioned. Going back to the question of, other people sitting on their laurels, everybody else did too. If the parents wanted to assert their parental roles, they could have stepped in and done that any time during this long period of early childhood parenting, and been involved in that. Their only involvement was to sign the consents late in the story.
Thank you, Mr. Booth. I had some questions and I needed them answered. Thank you very much. Proceed with your argument. I don't know
Well,
how much time you have left.
You're in a deficit position here. We have already exceeded the 15 minutes. I'll give you like 3 minutes for rebuttal. Mr. Hazlitt, I'll extend your time. You basically will have about 20 minutes if you want to use that. We don't obligate the parties to use all their time, but you'll have up to 20 minutes if you would like. And if you would proceed with your argument, you may do so. Yeah, Mr. Hazlitt, we're ready for you. Fire away.
One does not become a parent by self-proclamation. And without going into it in depth, I would say that the parentage actions described for DA are gross overstatement and eliminate the involvement of the ultimate adoptive mom. We did not choose to argue that because this is not a custody case. It began as an adoption case. It began, and adoption exists only by virtue of statute. The first adoption statute was in 1864 while Kansas was still a territory. And it controls absolutely. That's why it's not in the family law code. Most of everything that Mr. Booth has been saying and has said in the multiple TMMH cases is arguably from the family law perspective, not from the adoption law case perspective. With respect to consolidation, I might say that for many years, it has been a common practice for attorneys for the named father in an adoption to file a paternity case. That was eliminated in 2016. A committee was formed by the Judicial Council of over a dozen lawyers and judges knowledgeable in the field of adoption. As a result of that, 592136 D3 was made a part of the adoption code ultimately by the legislature. It specifically says that the adoption takes precedence over the paternity case. So the merger of the two eliminates what the concern was in TMMH. The other part is, in terms of an appeal, it would seem to me, and it was also in the TMMH case, the statute KSA 592401A-AB says that standing is not an appealable order. So in this case, he was found not to have standing, and yes, he was given notice and he was given an opportunity to be heard.
I don't want to be nitpicky here, but that case isn't this case. That's the adoption case. The case in front of us is the parentage, this other parentage case that DA has brought. Why was the district court correct in dismissing the parentage case based on res judicata and collateral estoppel, which is what happened, and that's what's in front of us? Why is that a correct ruling?
Right. Because the adoption case takes precedence. The parental rights have been determined. They were chosen, the adoptive parents were chosen by the biological parents in accordance with both statute and the Constitution.
Okay.
And
well,
that's
let me get a little more prosaic than constitutional rights. In the record in our case, the parentage case, is there evidence that there was a final judgment in the adoption case?
I don't know of specific, but I can tell you that on several occasions, I did acknowledge that, I'm sure, in the pleadings.
We can't find it. We can't find it in the record.
Well, then let's go back to TMMH. it says it doesn't matter whether it's final or not.
Mhm.
It still takes precedent.
Well, but you can't have a res judicata or collateral estoppel without a final judgment in the other case. That's one of the cornerstones of that ruling, or that doctrine, isn't it?
Well,
You have to have a
even
final
this-
judgment in case A to apply res judicata and collateral estoppel in case B based on case A.
Well, Mr. Booth earlier acknowledged that the adoption was final in his
Well,
argument.
he just said that right now, but what we have to go on is what's in the appellate record and what was in the district court record. And I'm asking what in the district court record establishes that there was a final judgment in the adoption case that would support a finding of res judicata or collateral estoppel in this case.
Well, I can't tell you specifically, other than what I said previously, that an adoption case takes precedent, and TMMH specifically said that it doesn't matter whether it's final or not. The adoption case still takes precedence. Now,
Well, but if it's not final, aren't the rulings that have been made in the adoption case interlocutory until they are final?
in what respect? It's not an appealable order when it was determined
Well,
that he was
okay,
not.
but let's assume, and we don't have any of this in the record, and that's the problem. In the adoption case, the district court ruled the DA didn't have standing. I gather, right?
Yes, absolutely.
Okay, well, and until there is a final judgment in the adoption case, can't the district court have an epiphany and say, oh my God, I realized I got that wrong. I'm changing that. He does have standing. That's an interlocutory order until there's a final judgment, isn't it?
I suppose you could look at it that way, but once the standing is determined, then there's nothing further that that person can do if they don't have standing. They can file appeals or whatever they want, but they don't have standing to pursue it. And in that sense, it has been determined.
Well, okay. All right, go ahead.
Well, you ask about the paternity case. There has been no service on one of the four respondents. She is not represented by counsel, and so far as I am aware, is totally unaware that anything is proceeding. There is no provision in the Kansas Parentage Act to terminate parental rights. It's only to create parental rights. And I particularly don't understand how a child can have, depending on how one wishes to interpret Mr. Booth's platings, 1, 3, or 5 parents. That is the only interpretation. One of those 3 has to be what his argument is. To do either 1 or 3, you would have to terminate the parental rights of the biological parents and or the adoptive parents. The summary judgment that was ruled on by the district court, filed by Mr. Booth or his client, did not pay the $195 that's required by hiding it in another pleading. Of the many versions of TMMH, the grandma's position is far better in the TMMH case than his is in this case. She had a court order giving her custodial rights. Nevertheless, regardless of the multiple opinions, she still was not able to prevail. And it might also be noticed in the record that the only reason this appeal even was docketed was because of COVID. Other than that, it was filed way too late.
Which appeal was that? The appeal in this case?
Or I'm sorry, yeah, the appeal in this case.
All right.
It was filed
Yeah.
some 3 or 4 months afterwards, and if it weren't for COVID, it would have been clearly out of time.
But does that mean we shouldn't hear it?
Well, we are hearing it, so that in a sense is moot. I'm just pointing out the various things that are not being done appropriately in this case from beginning to end.
All right.
Yeah, I might also speak just very briefly to the amicus briefs that are filed. First of all, I find the one from the grandparents' rights to be curious because they're both grandparents. And ultimately, no matter how you look at it, ultimately the biological parents have the say. And Mr. Booth's analogy may or may not be accurate, but whether or not, and there's a specific, and unfortunately, it just occurred to me, I don't have the cite on it, but there was an unpublished opinion that says that you can't look at the best interest in an adoption case. That was a AAT, I believe. And
It seems to me then you're saying that the first grandparent to run and file an adoption case wins.
if they have the appropriate documentation.
Yeah.
And the petitioner had the appropriate documentation, just never bothered to do it. Plus, it should be pointed out, if you look at the record carefully, it's unclear whether or not the petitioner is married. Some of his pleadings refer to the female raising the child as MA, but there's no indication they're actually married. If they are married, her consent would also be required. In short, literally nothing was done the way it could and should have been done. And now, in essence, what the petitioner and his attorney are asking the court to do is make up for his mistakes. As with respect to the brief by the social workers, at this stage of the proceedings, the best interest of the child is not an issue. When the two parents consent, that is their choice, and they have not been determined to be unfit, although I believe some of the pleadings refer to them as unfit. But the parental preference doctrine lets them do what they did. These are legal issues, and how the social workers' philosophy, if you will, has to look at it is insignificant. So I don't have anything further. I would just ask the court to affirm the ultimate decision and dismiss this appeal.
Any other questions?
No.
Mr. Booth, I'll give you 3 minutes to sum up and rebuttal if you would like.
Thank you, Your Honor. I continue to be flummoxed on 2 points. The first being how any issue preclusion, law of the case, etc., could apply to my client if he is not a party to the case. And the setup now, this idea that there was a parentage determination by the court when his son went and got the parentage orders that established his fatherhood somehow bars my client or affects his role. There are many scenarios we can come up with where confused parentage comes along and it has to be adjudicated. The idea that the parentage action doesn't terminate parentage rights is, I suppose, technically true, but you do have contestants of multiple parents in a parentage action, and the court has to settle that reality. So someone walks away believing they were supposed to have been a parent, believing somebody was supposed to have been a parent, and that person winds up not being a parent. That could be a termination of parental in that transition. So it's only in the sense of wordplay that we don't terminate parental rights. The adoption statute directs the court to go through the parentage action if there's a question on parentage, and to determine whether or not whose parental rights are at bay. And that,
Well, let me stop you there just a second. Isn't it true that oftentimes in adoption cases, the court will direct a parentage action to be pursued in order to clarify the issues for the adoption case? Is that not been the practice?
it has in the old statutory scheme and in the new statutory scheme. 592136H refers the court to the Parentage Act to do so. There's a direct connection. And so it isn't an issue that you do adoptions, and if you start an adoption, you can no longer have any question over parentage. And if somebody has a valid parentage claim, as David did, that they can't bring that before the court and have that adjudicated as part of the process. It's academic whether or not this putative parent has standing in the adoption case if the court is directed to deal with a parentage case. You could have standing in one case and not in the other. The determination of the parentage case would then put standing in the adoption case. And that's what missed here. There has to be some forum in which someone like David and his son have an opportunity for due process in this kind of scenario where you have out of the blue a existing relationship like this that has gone on for 6 years, and it is then scooped up and gone. We've talked about a variety of ways that could have happened. Proactive behavior, of course, is one, but that isn't what, there's lots of things that could happen in life that we could have, should have, would have done. But when we're confronted with these very, very fundamental issues about the care of a child, and they're all the things that the Amicus Briefs speak of, we must make these decisions carefully, and the participants must all be accounted for. And our decisions that are so fundamental to the rights of innocent third parties, and especially this child, are recognized. Thank you.
Thank you. Appreciate the argument of counsel and the briefs from them and the amicus. We will take the case under advisement, get our opinion as soon as we can. Thank you very much. That'll conclude this argument. We'll take up our last case in due course.
Mr. Hazlitt, thank you too.